try to keep contact with all of you guys. So as Ann said, I'm going to try to see if we can't make some sense out of civil procedure, or at least put it in an ordered format that you can use to address on the bar. There's a lot of material in the outline. I'm going to touch on the major points of it. I'm not going to go through the entire thing. And then, as she said, I am going to walk through the leisure question, the hot tub question, I guess it is, in the context of some of what we're talking about. Can everybody hear me okay?
Yes.
Okay, good. We turned the microphone off. I don't think we actually need it. So, preliminary, when you, okay. Preliminarily, with remember on civil procedure now for probably 7 or 8 years, the California Bar has required you to know both the federal rules of civil procedure and the California rules of the CCP. So as an initial matter, what you've got to do when you address a question is make sure you know what court ran. Right? There's no easier way to blow a question than if it says, it's in California and apply California law, and you've got the federal rules of civil procedure in your head, and that's what you address. So, just make sure that if it's that you know where the case has been filed, what rules apply. For example, State Court of California is going to apply the applicable law for the California court is the Code of Civil Procedure. If it's a federal court sitting in California, you're going to be applying both the federal rules and the Code of Civil Procedure. You apply California substantive law and FRCP procedural laws, and I'll talk a little bit about that when we talk about Eerie. And then finally, if you've got a federal court sitting in state X and they don't tell you what the state law to apply is, then you would apply the federal rules of civil procedure. So there are 11, actually 12 really heavily tested areas in civil procedure. And those are the ones that I'm going to focus on. I'm going to highlight them as I go through and kind of point them out. But I do want to list them for you so that you're thinking about them. Because for each of these areas, you're going to want to have the rules down cold and have kind of a roadmap. Have the rules committed in such a way that it creates a roadmap for when you get any one of these questions. Subject matter jurisdiction, removal and remand, in personam jurisdiction, venue, forum nonconvenience, choice of law and Eerie, pleadings, joinder of parties, joinder of claims, class actions, discovery, res judicata, and collateral estoppel. Those are your 12 major areas, and more likely than not, if there's a civil procedure question on there, it's going to hit one of these areas. So you want to know exactly what have in mind exactly what you're going to say, how you're going to address these different areas when it comes up, so that you're ready for them. So with that, I'm going to kind of jump into the various subjects. The first one, as I said, is subject matter jurisdiction. The preliminary question you've got to look at anytime you see a civil issue or an issue involving a court is, does the court have the power to hear the dispute? Is jurisdiction proper? Subject matter jurisdiction, as I said, is the first of the heavily tested areas. Usually you'll see the call of the question will involve a motion to dismiss for lack of subject matter jurisdiction. In federal court, subject matter jurisdiction comes from one of two things. Either a federal question or diversity jurisdiction. The second way that the jurisdiction is challenged is in personam jurisdiction. So subject matter jurisdiction in the federal court, as I said, is based on either diversity of citizenship or federal question. You need to know the basic rule that those are the, as soon as you see that there's a challenge to subject matter jurisdiction, you're going to say subject matter jurisdiction in federal court is based on either diversity or federal question. You look at diversity first, okay? Diversity, you guys may remember from years ago when you actually took your first year civil procedure class. There has to be, diversity requires citizens of different states or citizens of a foreign state and its subjects. And the amount has to be in excess of $75,000. So if you have a claim of at least $75,000, and you've got to have complete diversity between all plaintiffs and all defendants. Essentially, you've got to have diversity between everyone. The issues you will sometimes see with this when it comes up then is where or what is the citizenship of one of the entities or one of the parties, so as to whether you can analyze whether there's complete diversity or not. An individual citizen is considered a citizen of the state in which they're domiciled, in which they're living. The trick on that is it's domiciled with the intent to remain there. Okay? So, you know, one of the things you might see on that is somebody who is in a state temporarily for 3 months on business. Are they a citizen of that state, or are they a citizen of the state in which they, you know, their home is and their family lives? So most of the time when you see questions regarding questions regarding citizenship, however, they don't come up with individuals. It's raised in the context of corporations. You know, and from there, corporate citizenship is determined based on a couple of things. There's two different tests. The nerve center test, where the court looks at where the main decisions of the company are made, or their corporate headquarters, that kind of thing. Or the muscle test, where they look at where the main activities take place. Yes?
I've been confused on this issue, which is if plaintiff is a resident of California and they sue in federal court a company that basically has two domiciles, right, under sort of like the nerve test and the jurisprudence, which is to say the company is headquartered in Nevada, so it looks like we've got diversity, but they were actually incorporated in California.
Okay.
So the question is, could the company, in an attempt to defeat diversity by saying, yeah, nerve center test, we are headquartered, we do most of our business out in Nevada, but we were incorporated in California, this is a California plaintiff, we want to remand it back to state court. Can they destroy diversity there?
Yeah, I mean, and they're not even playing games to do that. Okay. I mean, the rules that corporations are considered citizens of the state in which they're incorporated and where they have their principal place of business. So you're not even playing games if you say, look, you sued me in California, I'm a California incorporated company, therefore there's no diversity. That's absolutely right. You know, the flip side of that is for example, you know, so many companies are incorporated in Delaware, right, in the real world, and therefore Delaware is always going to be an appropriate forum for those. But so yeah, you're right that principal place of business might be in Nevada, but a California corporation is considered a California citizen, right? So,
can I just ask a follow-up? I'm sorry, you answered it, but let's pretend that the company wanted to stay in federal court, as they often do. Could the court hear the case and allow it to stay in federal court under the theory that you've met the minimum requirements, and yes, most of your operations are in Nevada. I understand that you were incorporated in California, but this feels like diversity to me.
No, I mean, the court, more than anything else, is going to be bound by those rules as well. I mean, and they're not going to, the court is not going to walk down a path, well, you know, let's just leave it here because in this case, yeah, you're incorporated in California, but we're going to ignore that. That's not going to happen. Okay, so what you need to do is focus on the rule. Okay, and the rule says if you are incorporated in a state you're considered a citizen of that state, and then go with that. It's really kind of very much in the box as far as that goes. So, because otherwise then they'd have to have a whole separate test of, well, you could be a, but that's not the rule. So, okay. The second thing, in addition to, as I said, you've got to have complete diversity. You also have an amount in question of $75,000 or more. That has to be based on a, yes?
I got a multiple choice question wrong, because it said $75,000 in one penny. Is it $75,000 more or more than $75,000?
Well, 75,000 and 1 penny is more than 75.
More than 75.
Yeah, plaintiff must put more than 75,000 in, more than. Yeah, yeah. So, and how you figure that, the plaintiff has to put, it has to be a good faith estimate, okay? For that there'd be a reasonable expectation to recover in excess of $75,000, okay? So in your situation, 75,000 and 1 penny would need it. When you file a complaint, you don't always know exactly what your damages are, okay? And there may be circumstances where it comes up a little bit short, but that doesn't necessarily defeat jurisdiction. Did you guys look at have you done the leisure problem?
This was the bread for tonight.
Yes.
The one with the defendant that made the hot tubs and all of that? So, the last part of that question, okay, that's an interesting question actually, by the way, because the call of the question gives you 5 areas you're supposed to discuss, which in some ways makes it easier, okay, because it's laid it out for you and highlighted a couple of different areas. But the last part of that question goes to these facts. The jury returned a verdict for $70,000 in damages against Leisure and D. Immediately after the verdict, Leisure and D moved to dismiss Pat's suit, contending that the court lacked subject matter jurisdiction because the amount awarded did not exceed $75,000. The motion was granted. And then the call of the question is, was that the post-trial motion to dismiss, was the court's ruling correct? And what they're getting at there is exactly what I just mentioned, which is the court can look behind the pleadings at the time they were filed to see if there was a reasonable basis for expecting that the damages might exceed $75,000. Okay, in this case it came into $70,000, but the rule generally is that as long as plaintiff makes a good faith claim, unless it was clear to a legal certainty that there wasn't enough in controversy, the court will still consider it. Okay? And they do that by looking at what is claimed in terms of the things that make up the damages. I think in this question, the facts they looked at, do you guys have this question?
Yeah.
Okay, take a look at it and tell me what they said, what kind of damages they were talking about, and whether, it might be reasonable to assume that the damage would be more than $75,000. Yeah, they water damage. Yeah. I think the way they say it is water poured through the house, damaging hardwood floors, oriental rugs, artwork in the ceiling in the room beneath the tub's location. On the face of that, does that sound like that could be something that could be over $75,000? Yeah, I mean, you're talking about damage to a floor, to a room beneath, artwork, all that kind of stuff. So, the fact that they make an initial allegation that sounds like, okay, if it's all those things, that could definitely be over 75, and then it came in at around 70. So that's, the court's can look at the pleadings and determine, jurisdiction was likely appropriate. So, what you have to look at is what is pled. If they said, the water heater exploded and it ruined the bookcase, that's probably not going to be enough, right? So, but otherwise you can't. People can get tripped up on that. because you get in your head, oh, 75,000, it's got to be $75,000. So just remember, if it's close, think about what was originally pled. So, additionally, in terms of amount and controversy, remember also that the plaintiff can aggregate all the claims against the defendant, but multiple plaintiffs and multiple defendants cannot. Also, something else you might see, we didn't see it in this fact pattern, but some of the things that you might also see that they like to test on this is there was an additional claim for punitive damages and for attorney's fees, and whether those things can be allowed as part of the amount in controversy. And the answer on that is that if attorney's fees are permitted or recoverable by the statute, or if punitive damages are permitted, then you can count them. So, if it's something that you can't get punitive damages for, then the punitive damages aren't going to help you. But if it's otherwise allowed, you can add it into the amount in controversy. So, I'm going to mention this again in a minute when we talk about the Eerie Doctrine and choice of law, but remember that in diversity actions, federal courts will apply the substantive law of the sitting state and federal procedural law. So you're applying the law of the state that you're in for substance and federal procedural law. So the first leg of subject matter jurisdiction in federal court is diversity. The second leg is federal question. So federal courts have original, non-exclusive jurisdiction over federal question subject matter. And what do I mean by that? The obvious one is cases arising under the Constitution, but it's the Constitution, laws, and treaties of the United States. And the federal question must be properly pled on the face of the complaint. So, in some cases, you may have a federal question and state claims in the same action. Although there may be no diversity, if there is a federal question, the court has the discretion to exercise what they call pendant jurisdiction over the state court claims, as long as they arise from the common core, or I should say common nucleus of operative facts. So, I was going to say a couple things about California subject matter jurisdiction in California state courts. Generally, state courts have general jurisdiction. Superior courts in California have jurisdiction over any amount in controversy over $25,000. Limited jurisdiction for matters under $25,000, and small claims court has a $75,000 limit. So, excuse me, 7,500. Thank you. 7,500. Yeah. Yeah, how they hear it, the level that they'll go into. The other thing is where you appeal it to. Okay, Superior Court handles appeals from limited civil cases, and then and from small claims. So it's essentially the same. And I think for bar purposes, you just need to recognize, that it's different, but it's not a huge issue. So. Okay, so we started talking about what federal courts can hear. I want to flip it for a second and talk about concurrent state and federal jurisdiction. In other words, can a state court hear federal questions? State courts presumptively have jurisdiction even over claims that arise under federal law. Right. So generally, the state court can hear constitutional questions. Right. The only areas in which a state court cannot hear a federal question is in areas where a statute has given federal courts exclusive jurisdiction. Okay? And what we're talking about primarily, antitrust, bankruptcy, copyright, that kind of thing. Because those are, for example, bankruptcy, there's federal bankruptcy court. And they've got exclusive jurisdiction for that. And then, so a state court can't hear bankruptcy issues because those by statute are given exclusively to federal court. But other than those exclusive areas, and then, as I said, the big three are bankruptcy, antitrust, and copyright, state courts can hear federal questions other than those for exclusive federal statutes. Okay. So I want to move on to the next issue. That is one of the big issues that is tested is removal and remand. Right? This is another area where you need to be, fully conversant with what each one is and what the standards are for it. And whether it's a removal or a remand issue depends on what state what court you start in. Okay? Basically, removal is from state court to federal court. Okay? Remand is from federal court to state court. Plaintiff always picks the court. So in the first instance, it's the defendant who has to have it either removed from state court to federal court or remanded. I should say removed from state court to federal court or remanded from federal court to state court. If the defendant's motion for removal has been granted, the plaintiff can then counter move to have it remanded back to state court. So again, usually what you're looking for is either the plaintiff files a case in state court and the defendant wants to move it from state court to federal, filed in federal court, defendant wants to remand it to state court, or again, the removal motion is granted and then the defendant, or the plaintiff wants to move it back. So, as far as the rules on this go, again, once you spot the issue, you need to know what the rule is. An action can be removed from state court to federal court within the same geographic area if the action could have been originally brought in federal court to begin with. Right? So what does that mean? You can remove something from state court to federal court if it could have been brought in federal court first. So what do you have to do? You have to analyze whether jurisdiction is appropriate in federal court. Okay, that's the analysis that we just talked about. Right? You have to look at whether there's subject matter jurisdiction, again, either based on diversity of citizenship and $75,000, or a federal question. Okay, so you've got to do the same analysis for removal as you would do if the question asked, is jurisdiction appropriate in federal court? You're doing the same thing when it says defendant is trying to remove to federal court. You have to analyze, is it appropriate in federal court?
I'm sorry, so you do a full analysis on federal question, diversity?
Yeah, because you can't remove it if what the plaintiff is asking to do is to send something from state court to federal court, right? It has to. So in order for the federal court to take it, you've got to have, it kind of makes sense if you think about it like that. The federal court can only hear what it's authorized to hear, right, under subject matter or federal question. So if you've got something in state court, you still have to look and see if there's a hook to get it into federal court. That's why you've got to do the same analysis. Does that make sense? Yeah. So, okay, so for remand, again, you're dealing with something that was filed in, remand was filed in federal court and they want to move it to state court. It's kind of the flip side of what we were just talking about, which is if the plaintiff can show that the federal court, or the moving party can show that the federal court doesn't have appropriate jurisdiction, then they will in fact remand it to state court. Okay? The second reason that you can argue and that it ought to be remanded is there's complex issues of state law that dominate the case, or there's an ongoing state regulatory issue. But most commonly what you'll see in the fact pattern is something that's basically, there's state law issues. The case is really about state law issues. And, you know, on a realistic level, the federal courts don't want to hear state law. They want the state court. They want the state courts to determine that. So, okay. Let's see. The third major area of our 12 is in personam jurisdiction. This one isn't just heavily tested, it's like really tested. Okay, it's kind of like they default to it, if not on every bar, certainly almost every other one. So, in personam jurisdiction, whether the case is being heard in a state court or a federal court, the basic premise behind in personam jurisdiction is that the court has to be able to constitutionally assert jurisdiction over an out-of-state defendant so as not to violate notions or due process clause of the Fifth Amendment. Right? You generally see this raised by a motion to dismiss based on a challenge to jurisdiction. In federal court, it's a motion to dismiss. In state court, it may be a special appearance where the defendant specially appears to consent to contest jurisdiction without consenting to jurisdiction. Okay. Remember, if you see something where a defendant answers a complaint and then they want to say, oops, you don't have jurisdiction over me, what's happened? They've already waived it. If you appear in state court, you're considered to have consented to jurisdiction, unless you specially appear to challenge it. So, again, in personam jurisdiction, personal jurisdiction, you have to address kind of a two-tier approach. Okay? The first thing you want to look at is the easy, what I call kind of the easy basis or the obvious basis for personal jurisdiction, which is the traditional means. Okay? A party's personally served within the state, or there is residency in that state. The party consents to jurisdiction, or the last one would be the out-of-state defendant falls within the long arm. But for purposes of the reason I call them easier is because when you're addressing a question, you can kind of click through these three pretty quickly, and you still should should mention them. Okay, even if you read the question and you know, okay, they're going for diversity and whether there's minimum contacts and all of that, you still want to say, you know, there's traditional basis for jurisdiction, which again would be personal service in the state, residency, or consent. And then you talk about whether any of those three are present. Okay? Assuming they're not, you would then get to the minimum contacts, or the state long-arm statute, which comes down to a minimum contacts analysis. So, states' long-arm statutes, in California, California's long-arm statute extends personal jurisdiction to the fullest extent allowed by the constitutional Fifth Amendment due process clause. Okay, so if you're dealing with California, that's what you would say. You would say, you know, California state's long-arm statutes, one that extends personal jurisdiction to the extent of the Constitution, such that there has to be sufficient minimum contacts to not offend traditional notions of fair play and justice. Once you make that statement, then you go on to analyze the facts that they give you based on kind of the minimum contacts factors or tests. There are it's a 5-pronged test for minimum contacts. These are something you guys need to commit to memory, because if you get a personal jurisdiction question, you're going to need to analyze it using the the 5 prongs. Okay? Again, but then when you do that, it gives you a roadmap for writing your answer. Okay? The constitutional standard of minimum contacts is judged by, in the first instance, well, the International Shoe Test says that there's got to be sufficient minimum contacts between the defendant and the state to make it just and fair for the defendant to be called to answer in that state. Once you've got that rule, then you look at, okay, what are the contacts that are given here? And let's analyze them using the 5 factors. Here are the 5 factors. Systematic and continuous activity within the state. That's the Burger King test. Purposeful availment of the benefits of the state. That's Hansen versus Dekla. And this is one area, by the way, not every area of the bar or every subject matter requires you to know case names. In this particular area, it's helpful to have not just the factors, but the case that it comes from. Because when the grader sees it, they're like, okay, they got the Burger King test, they got the, Hansen versus Dekla, and they're almost looking for the case name as much as they are for the test. The third factor is that the claim arises out of defendant's activities within the state. Fourth, worldwide Volkswagen test is foreseeable injury in the state. And then the fifth is a balancing of fairness factors. Okay? The exercise of jurisdiction has to be fair to the non-resident party. So if we go back to our leisure question, there is, the first paragraph, so somebody want to read me just the first paragraph? And then I want to address the factors, have you address the factors we just talked about. Go ahead. I don't have to read everything, I'll let you guys do some of it.
Non-resident state A purchase and/or contract from leisure. State B mail or promise to often advertises in state A newspaper. In the past year, leisure sold a dozen hot tubs to residents in state A. D, a corporation having its primary place of business in state C supplies pumps and heating elements for leisure products and occasionally fills pumps with fencing wires for individual hot tub owners, some residing in state A.
Okay, so what does that tell? When you start reading that, that should trigger, okay, I'm looking at a plaintiff from state A dealing with a defendant from state B who, does, and then a second defendant who's incorporated in state C. So that's triggering first, that should make you think right away, this is going to be about diversity. And in fact, paragraph 3 goes on to say, Pat brought a diversity suit in federal court in state A against Leisure and D, claiming $80,000 in damages. So the first call that they give you is that the defendant moved for dismissal of the complaint as to it on the ground that the court lacked pure personal jurisdiction over D. Okay? So you've got a plaintiff in state A, and you've got a defendant in state who is incorporated in state C. Okay? D moves to dismiss based on the lack of personal jurisdiction. So we've got the 5 factors to take a look at. What's the first factor? Systematic and continuous activity within the state. And you have to do, what you do is discuss the defendant's contacts within the state and apply the facts to it. So D is a corporation having its only place of business in state C, supplying pumps and heating elements to Leisure, who ships products to state A, and occasionally fills replacement parts for individual tub owners, some residing in state A. You think that that's systematic and continuous? No? Because why not?
Occasionally replace parts
they replace parts to people that live in State A once in a while. But they also provide significant product, I think, pumps and heating elements to leisure who does, I think, do business in State A on a regular basis. You know, but that's the analysis that you would make is, look, you know, it just shipping parts to, isolated parts to people, some of whom are in A, isn't necessarily purposeful availment. I should say systematic and continuous activity. The second one is a closer call. And if you're shipping a lot of parts, if you're supplying parts to somebody who does business in this jurisdiction, you know, that's a closer call. But you need to apply to both sides of the facts. A similar argument would be made for I can't say that today, purposeful availment, okay? Which means, is the defendant taking advantage of the state's services, benefits, protection of the laws? You know, the plaintiff, again, is going to argue that filling replacement orders is enough. The defendant's going to argue that it's not enough. Again, this is one of those that they're really not looking necessarily for the answer one way or another. They just want you to point out both sides of it and come to some conclusion. Claim arises out of defendant's activities within the estate. In this instance, the claim did arise from products that this company made that was shipped to the state. So, you know, I think that they probably lose on that one. And again, you had then analyzed whether you've got foreseeable injury and fairness factors. Do you think that this defendant who supplies parts to leisure thing will agree that that it's foreseeable, the injury is foreseeable? Christine, do you think so? Is that, sorry, it's not Christine, is it? No. It is, okay. We met before. Didn't you go to Loyola?
Yeah.
Well, way back when you were there.
Oh, okay.
So, that's okay.
Yeah, it was foreseeable because you are putting, you're supplying the majority of the pumps and heating elements to the user who's very large.
That's what the plaintiff's going to say, and you're right. That is what the plaintiff's going to say. The defendant's going to say, "Yeah, they're providing parts to it, but they're really not selling that many, you know, that many hot tubs in State A." And to think that, you know, if there's only 12 of them or something in State A, then, you know, it's not really foreseeable that something's going to go wrong with one of those 12 and end up having an injury in that state. So, and then lastly, again, the fairness factors is really just sort of balancing the fairness to each side. Even if there are minimum contacts, there still has to be a balancing of convenience to the parties and the state's interest in hearing the case. Okay. Yeah.
So all of this that we just discussed is all under the long arm statute. That would be the header?
Yes.
Long arm statute is the header. And then
Yeah, long arm statute is, first you've got, the headings you would put would be, first you'd have traditional basis, and you'd go through those three. Then the second would be long arm statute, and then you would have the main rule that says, you know, it has to comply with traditional notions of fair play and justice. And then you would say, you know, that's based on analysis of these 5 factors, and then I would go through it factor by factor.
So tier 1, this separates into the minimum long statute. Tier 1 is the fair play, substantial justice, and tier 2 is the minimum contract.
Well, tier 1, what you're really looking at tier 1 is just, yeah, tier 1 is just determining what the state's long arm statute is. Yeah, that's really just it. And most of the time it's going to be, the California statute, or they're going to tell you what it is.
So the
Okay.
tier one's kind of easy.
Yeah, yeah. Once you just figure out what the, and then from there you go into the other ones.
Okay.
So it's not like a 50-50 tier. Yeah, it's sort of like an entry portal, and then you go. Yeah. That's correct. You can raise subject matter jurisdiction at any time. Right.
Looking at, so there's a one paragraph, and then there's 5 different factors. It seems like there wasn't that much factors analysis. It sounds like there were a lot of different factors. You want to do systematic, it seems that you would still go through the same 2 facts that they supply to leisure, and they also need to teach and care. If you go to the second, like purposeful availment, you use the same facts again. It seemed like there's like not enough facts. I think it's more like a teaching matter. There's like 5 prongs. You need to discuss personal jurisdiction. You need to discuss subject matter jurisdiction and like some venue or venue issue. There's like a lot going on.
Yeah. See, that's why you don't have, particularly, they didn't give you a lot of facts on the jurisdiction point because they gave you 5 different issues they want you to address.
Right.
Okay. So in a question where without 5 calls, you might have had more factors to argue each way. But because this one, they kind of, and that's why I said, you know, in some ways, when I said at the beginning that this question is kind of easier in some ways, is because with 5 calls and not a lot of facts, it's really kind of down and dirty on each one, as opposed to, you know, a more detailed analysis.
But you would still like pay that the kind of.
Yeah, you still would do it the same way. Because again, when they're grading it, they're checking off whether you did the 5 factors. Yes?
This question was from, I think, 1990 as well, 25 years ago. Has there been any like, changes in the trend, or is this still pretty spot on for what like the same question we see?
Yeah, I mean, in this area, the bar hasn't changed a ton. So I think you're still, you know, it's still reasonable to go with something like this. Yeah.
Does it make, sometimes when I mean, me personally, actually, does it make, is it a difference between subject matter or personal, or personal is the same?
You know, you mean as far as,
You know, the analysis, you're going to have to address both of them.
right.
And so whether we do personal before subject matter, or the opposite, or whatever.
Usually you do subject matter first, just because it's a threshold question. You know, I mean, if the court doesn't have jurisdiction to even hear the case, they're going to kick it out on that. You know, so as I say, you know, as a threshold question, it's usually a good idea to do subject matter first and then personal. You know, and I think that that's again the way that the answers are probably structured, and that they're used to seeing it that way. And if you can give it to them the way they're used to seeing it, then that helps. So, okay. Let's see, where were we? There are a couple of other bases for jurisdiction. They don't tend to be tested as much, but you do need to be aware of them. There's in rem jurisdiction, which essentially is where the court has the power to adjudicate the rights against all persons in the world with respect to a particular item of property. Usually it has to do with, you know, land, something that's located within the physical borders of the state. So a court can exercise in rem jurisdiction over it. Quasi in rem is a form of jurisdiction where the court can attach or garnish property within the state, but the judgment will be limited to the property. Again, I wouldn't spend a ton of time on those, but just be aware of what they are and the differences. However, the fourth tested area is venue. Okay? Well, now, first you look at whether subject matter is appropriate, then you look at whether there's personal jurisdiction. Venue is about whether the case is in the right place. Okay? Again, this is one of those where the first thing you need to look at is, am I in state court or federal court? And make sure that you're applying the right rules. Talking about federal venue, in diversity cases, venue is proper in any district where either all the defendants reside, where there's a substantial part of the claim arose, or if neither one of those is possible, then any district in which any defendant is subject to personal jurisdiction. Okay. So again, you need to remember the rule for venue is it's appropriate where all the defendants reside, where the claim arose, or if you don't have one of those, then you default to any district where any of the defendants is subject to personal jurisdiction. So, a substantial part of the claim arose is sometimes are the facts that you're often tested on. And you have to talk about, using the facts, you have to analyze where the claim arose. Where did the accident occur? And that's usually a fairly, a fairly easy one. If something blows up, then that's where the claim arose. But there could be other facts out there that are less obvious than that. So, or if there were, arguably two different places where it arose, then venue might not be appropriate where it was filed. So, that's diversity actions. Remember, we have two bases for subject matter jurisdiction in the federal court. The second one is federal question. In federal question cases, though, the rule is similar, which where any defendant resides, where the claim arose, or if you can't get where the defendant resides or the claim arose, then it's appropriate in anywhere that any defendant can be found. So, for purposes, again, of a corporation, the proper places for venue of a corporation are its principal place of place of incorporation, where it's licensed to do business, and where it's doing business. So when you're dealing with venue for a corporation, if you think about it, proper place for venue is its place of incorporation. So that gives you the state of incorporation, to go to your question earlier. So in your question, it's doing business in Nevada, incorporated in California. Venue is going to be appropriate in California, right? Or where it's licensed to do business, or where it's doing business. If it's doing business throughout the United States, if you're Target Corporation, okay, where do you think venue is going to be appropriate for Target? What?
All 50 states and beyond.
Pretty much everywhere, right? I mean, if it's Target, they're not going to be able to say, venue's only appropriate in it. I know there's a nice Costco in Hawaii, but yeah. Anyway, so that's what you. Yes.
If they're incorporated, doing business, two different states, and then let's just say they originally intended to do business in Washington, so they got a license to do business there, but they never stuck foot in the state line, and they still have a valid license to do business there.
It would be good. Then you'd have to ask, how did that get there? I guess if you've got a plaintiff in Washington who wants to sue over something that happened in California, but they live in Washington, and the company is licensed to do business in Washington, then venue would be appropriate. What's that?
So that alone is good.
Yeah, it's kind of like the issue I was talking about with this gentleman earlier. What's your name? Mose. That it doesn't, even if you're incorporated someplace, you never do business there, it's still your state of incorporation is something that counts. And it's the same way with these rules.
In that example that I just gave, wouldn't you actually do a minimum contacts and sort of, could a federal court in Washington assert personal jurisdiction over a company in Nevada if yes, 20 years ago, filled out a business application that doesn't, from a constitutional standpoint, have any minimum contact with the state?
But where you go back to is if the party's personally served in a state or they're a resident of that state, okay, And so let me think about your question again. You're saying, is there personal jurisdiction in Washington over a company that's incorporated or licensed in Washington? But personal jurisdiction isn't based, the test for residence for a corporation this is the venue rule that says licensed to do business, okay? But if you go back to where we were on the different tests about where a corporation is a citizen, again, it's based on their principal place of business or their incorporation, not their licensing.
Right.
Licensing applies only to yeah.
So hence you have a personal jurisdiction argument that Court of Washington, in fact, doesn't have jurisdiction over you as a company, even though...
If that's what you saw in the facts, that's probably what they're going at. Yeah, they're probably going after that. Yeah.
I'm trying to wrap my head around this thing. So if we talk about subject matter jurisdiction, personal jurisdiction, haven't you already proven that venue is supposed venue? Or would that be a separate and sole question that you haven't discussed?
Venue is jurisdiction is, federal jurisdiction is the power of a federal court to hear something, okay? Venue is whether it's appropriate to have that in the federal court for the Central District of California, or whether you can file it in the Eastern District of California, which is in Fresno. Okay, so...
Once they decide that they can hear it, where...
Right, which federal court can hear it? Okay, does that clear that up? Good. Okay. Are you guys good at taking short breaks?
Yeah.
Okay. How about take like literally like a 5-minute break? Okay, and I'll give you another one later, but I need to go clear my throat because I'm still getting over from being sick. And I'd rather do a couple of short breaks than long, but I don't want them to go really long and then, you know. But if you guys can come back by 5 after.
Cool. Thanks.
And we'll start with forum nonconvenience when we get back.
response to initial was, that's why I asked. So, and it was, she was pretty yourself with her. She was like, but it was pretty fun. Like, they were like, I said, you should just yeah. Guess what? Disclaimer. You might be wrong. Dude, one of those is going to be on there, dude. Maybe not all. One or two. Yeah. Yeah. Yeah.
You're going to give them another break, right?
Yeah, I'm going to give them another break. I said I'd just give it 2 short ones. You want to do it now? Okay. 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 Okay, is everybody back? I think everybody's back, right? You guys are good. That means you get a second break, right? So, the next thing that I want to talk about that relates to what we were just continues with what we were just talking about under change of venue is the concept of forum nonconvenience. And this actually goes to the question that the gentleman in the back, what's your name? Oliver. This actually addresses your concern about, well, what if they're licensed but they don't, they've never done anything there? Is it still fair to have, is it still fair to have venue there, right? And I answered the question with, on the strict sense, yes, venue is appropriate there, okay? But there is the concept of forum nonconvenience, which says that even if venue is originally proper, a court can still transfer venue to another court where the suit also could have been brought if the interests of justice so require, okay? the federal rules incorporate the doctrine of forum nonconvenience. It allows the federal court, for the convenience of parties or witnesses, and in the interest of justice, to transfer a case to another federal district where venue is also appropriate. Okay, so in Oliver's example, where the venue was based on the fact that the company was licensed to do business in the state of Washington, therefore venue would be appropriate there. But his point was, but is that really fair? They don't really do anything in the state of Washington. Then the court could consider a motion to change venue based on the doctrine of forum nonconvenience, which is another area where there are 5 factors that you guys need to know. Okay? They come from the Piper aircraft case, and the 5 factors are the convenience of the parties, the convenience of the witnesses, the state's interest in retaining the case, whether the laws of the alternative forum impair a substantial right of the plaintiff, a foreign court's interest, if any, in hearing the dispute, if that's relevant to the matter, and the availability of an alternative forum. So what you would argue in Oliver's example, for example, is the convenience of the parties and the convenience of the witnesses would say that there's really no connection with Washington, right? And that the witnesses are probably down in California or wherever it occurred, and that it's inconvenient for the parties and the witnesses to have to go to Washington. So again, that's the doctrine of forum nonconvenience, which has been incorporated into the federal rules at 28 U.S.C. 1404 and 1406. Yes. No, it's okay.
Forum nonconvenience. So if we're talking about Washington State and the Northern District of Washington State, verified.
Right.
Forum nonconvenience, can that also be moved to the southern half of Washington State, or are we talking about out of state?
Well, if they could argue that Northern District of Washington versus Southern District, one is more convenient, but the argument is you get is how much more convenient, right? On the other hand, if you're talking about licensed in the state of Washington, but the the incident took place in Florida and the company's primarily there and that's where the witnesses are, then that's a little bit, then that's different. I mean, venue would be appropriate in either place. So when you're looking at it, what you're really looking at is the degree of convenience or inconvenience for the parties or witnesses. And certainly traveling from one part of Washington to another, I'm not sure how much you're going to get that. Certainly from Florida to Washington, you're more likely to prevail on something like that.
Is the vehicle a little different as well? What I mean by that is when you file a motion to change venue, the court, my understanding, the court is not dismissing that case, whereas you usually file a motion to dismiss based on forum nonconvenience, meaning the California court dismisses the action in California, doesn't transfer the action to Florida.
Well, it's not a motion to dismiss, it's a motion to change venue. Again, this used to happen in bankruptcy cases all the time, where you can, almost every large public corporation is incorporated in Delaware. Therefore, it's appropriate to file, venue is appropriate in Delaware, okay? But you've got a California corporation that really only is doing business in the western states, right? And so why is this case in Delaware? Other than, the company's incorporated in Delaware, so they'd move it to California. But no, this isn't, you don't dismiss when venue is improper, you move it. Unless, under 1406, you want it to be dismissed on the contemplation that it's going to be refiled in a foreign jurisdiction. Okay, but courts are really reluctant to do that. And, what you guys are going to be seeing, more likely than not, when you see venue, is a motion to change venue based on these things. Forum nonconvenience, yeah. Okay. In California, there's just a couple of things to keep in mind. There's a couple of there's a couple of areas where alternative venue kind of trumps the general venue rules. And what I mean by that is in personal injury cases, okay, venue is proper where the injury occurs or where the defendant resides, okay? It's automatically appropriate in those two areas. And in contract cases, venue is proper where the contract was made, or it's to be performed, or where the defendant resides. Okay. So just to kind of circle back to, is it Mo's?
Yeah.
Yeah, Moses' question. Usually the remedy for a forum nonconvenience is to stay the action in one court and move it to another court, not to dismiss unless you're dealing with moving it to a foreign court. So
When you say foreign,
we're talking about forum, yeah.
that's,
Yeah. So, okay. I'm going to move on to another area that's highly tested, which is choice of law. But before I move away from jurisdiction, I just want to remind you guys that it is jurisdiction meaning both subject matter jurisdiction and in personam jurisdiction are two really heavily tested areas. Right? And it's usually a two-step analysis. Does the court have authority to hear the matter, and is it appropriate to hear the matter for this particular defendant or plaintiff? So, choice of law. This is what law you apply, in particular in federal court, in diversity cases. Under Federal Rule of Civil Procedure Rule 4, courts sitting in diversity only have jurisdiction to the same extent as the courts of the state in which the federal court is located. The issue for choice of law in diversity cases is what's called the Eerie Doctrine. Okay? And the Eerie Doctrine determines whether the federal court should apply state law or federal law. And this is an area that people get tripped up on a bit. There was an Eerie question on the last bar. And there was an Eerie question on the July bar. But the general rule is this, okay? The Supreme Court has determined, what's? No, it's the other, I'm sorry, it's the February bar. That's what I was, yeah. I was thinking that you told me that. Yeah. No, you're absolutely right. It was the one before. I forgot it was last February's bar that there was an Eerie question. I was thinking about somebody who had told me that, who passed the July bar, who didn't pass the February bar, and was talking about the Eerie question. You're right, it was on the February bar. So not to throw you guys off, but it was on, a year ago's February bar, not on the July bar. Okay. So, to discourage forum shopping, okay, and to avoid inconsistent results, a federal court sitting in a diversity jurisdiction applies state substantive law and federal procedural law. Okay? Sorry. There is a test from a case called Hannah, a Supreme Court case, that said it's a policy test, and it says that the federal rule of civil procedure will apply if the rule of law upholds an important federal policy, that federal rules are presumptively procedural. However, and this is where people get tripped up, okay? Again, state substantive law and federal procedural law, okay? The Eerie Doctrine says that a state's statute of limitations is substantive. Okay? And I think instinctively a lot of people want to say statute of limitations, that's procedural. It's not, okay? Under the Eerie Doctrine, the state's statute of limitations is substantive, and again, so a federal court sitting in diversity will apply a state's substantive law and the federal procedural law. So that if the question is, the state's statute of limitations is different than the federal statute of limitations, which one do you apply? Okay, yeah.
That would be a pretty brief analysis of what happened, right?
Well, we're actually going to do one.
Okay.
So yeah, they raise that in this question. Okay. If you look at paragraph 3 of the leisure question, it says Pat brought a diversity suit in federal district court in state A against Leisure and D, claiming damages. Complaint was filed 2 weeks before the applicable state A statute of limitations lapsed. Service of process by mail in accord with state A long arm statute, which extends jurisdiction on any basis not inconsistent with the federal constitution, reached D in 6 days. Okay? Because of the delays caused by the post office, service did not reach Leisure for 3 weeks. So what that question is saying, what's the issue that you've got? Service of process, the complaint was filed 2 weeks before the applicable state statute of limitations lapsed. Okay? The service was not made until 3 weeks later. Okay? So it goes on to say, okay, read that for me.
The applicable state aid statute holds the statute of limitations of aid services received. Federal rules of the procedure provide that the action is commenced by filing.
Okay, so then what's the problem that we have?
According to the state statute of limitations, service was too late within that.
Yeah, so to go to your question, right, then what would you say on this?
I would say that statute of limitations is substantive to the state law applies.
And this is another, by the way, this is another rule that I would name drop. I mean, I would drop under Eerie.
Eerie Doctrine.
Yeah.
But I mean, beyond two or three sentences, it's really a quick analysis, right?
I see another opportunity here, which is it does go to a quick analysis, but then couldn't you do a choice of law analysis on if you're in federal court in diversity of 2 states? It's often the case that one state has a longer statute of limitations than another state. And so under a choice of law analysis, you make an argument under a government interest test as to why the state with the longer statute of limitations actually applies to you, and thus you weren't barred by the statute of limitations.
If you were doing that in this question, you just wasted a lot of time and got no points for it.
Right.
Okay? I mean, because this says there's a federal statute and a state statute. So you don't need to go into state by state. Okay? Not necessarily a bad argument, but one that's not going to get you a darn thing.
But it's possible that that could be in a fact pattern, right? Which is that there's
2 states versus, but I
you're in
mean,
federal court in diversity, you've blown the statute in state A, but you could apply the statute in state A.
Eerie and ask you and why you apply Eerie to 2 states.
no, Eerie, because Eerie is meant to help you decide between federal law and state law and whether it's substantive or procedural. So, yeah, I mean, you would say, that the defendant's going to argue that the federal rule applies and that therefore it wasn't timely met, but plaintiff's going to argue that the state A statute trumps the rule and that it applies, and your conclusion is yes, that they're correct on that. And that is really pretty much all you have to say about it. As long as you, again, state the rules and apply the rules using the facts, even if it sounds obvious. You've got to show your work on all the way through the steps. It's like a math problem where you don't want to just, remember when anybody take algebra or algebra 2 and you had the x plus y and then you had to kind of narrow it down to the bottom and they always said show your work? Do you remember that? You hate it, but on this you've got to show your work. It's not just the conclusion. That's why you hated the math?
That's right, because you have to ask them everybody to show the work.
And you know what? That's the same thing here. If you don't show the work, you're not going to get the points for it.
So here on this question, this specific thing, there's really no hierarchy that you can do. I mean, it's really only about lines, right?
Yeah, I mean,
As long as you work with the
But exactly what we just said. You know,
So your doctrine is substitute, it's a state substitute.
so yeah, and I think you would say, I do think that you would walk through that, you know, the defendant or the plaintiff's going to argue, well, I've got my people there, but you know, the one side is going to argue that they want the federal to apply. But the federal is not going to apply because, exactly,
We'll just ping pong it.
a little bit, right, yeah. Right, right. So, yeah, I mean, you know what, it's not, if you remember it and you spot it, it's not that hard. You know, but it was worth, on this particular question, it was worth 10 points. So, okay. Let's see. All right, area number 6. This is one where, this is the area of pleadings, okay? Some of the things that the bar can test on this is whether things are properly pled, or this is another area where they could actually test on the California rules because they're a little bit different than the federal rules. The main difference between pleading in California and under the federal rules is the federal rules are notice pleading. Okay, you guys remember what that is? Which is just a basic. All the plaintiff has to do is allege enough facts so to put the defendant on notice of what the cause of action is against him or her, and really sort of broad pleadings are appropriate, okay, under the federal rules and under the notice pleading. California state pleadings, on the other hand, California is a code pleading state, not a notice state, not a notice pleading jurisdiction, and therefore you have to have more factual details in the complaint than you do under notice pleadings. Also in California, in particular in California, there are heightened pleading requirements in addition to having to plead all the elements, not just on notice but with more particularity. In the area of fraud claims, you have to really plead all the elements with specific particularity. The other area of pleadings that seems to get somewhat heavily tested, and again, if you see it, it's not that difficult of an issue, so be glad if it shows up on your exam, has to do with attorney signatures, okay? Under the federal rule of Civil Procedure Rule 11, which I think most of us know is kind of the sanctions rule, but it also covers other things as well, and under the California CCP, at least one attorney of record has to sign the complaint. Okay? The complaint has to be signed, or if there is no attorney, then the party must sign it. But you can't have a complaint that is not signed. The reason why complaints have to be signed is that a signature verifies to the court that basically 4 things. By signing the pleading, either the party or the attorney is certifying that to the best of their knowledge that none of the following conditions exist. You are verifying that the complaint is not being presented primarily for an improper purpose. In other words, improper purpose being simply to harass or delay or increase the cost of litigation. Second, you're warranting that the complaint is, in fact, supported by existing law. In other words, it's not frivolous. You know, that what you are arguing and what you're seeking is, in fact, supported by applicable law. It's also warranting that there's evidentiary support for it, or you believe that there will be evidentiary support upon further investigation and discovery. But in other words, that it is supported by some sort of facts. And that, lastly, any denials of facts when you're answering a complaint or otherwise, that those are in fact also warranted and reasonably based on information or lack of information. So to kind of summarize that, a lawyer's signature on pleadings basically says that the pleading is not presented for an improper purpose, that factual contentions have evidentiary support, that the claims and defenses are warranted by law, they're non-frivolous, and that any denial of the facts are also supported by a good faith belief in the truth. So, yeah.
So since it's heavily tested and you have a fact pattern that most likely the attorney didn't say, is that what's going to happen? Or do you have to like
Well, you might have something where the attorney doesn't sign it, and you need to raise, you raise that issue. On the other hand, if you're dealing with the facts they give you say, the client says he wants to, he really doesn't think he can win and doesn't really care if he wins, he just wants to file a lawsuit, then you know it's one of these, and that it should trigger that. So that's why I said it's not really that. If you think of these 5 factors, they should be kind of easily triggered by the facts. Yeah, Amy?
Ultimately, if it's not signed, it's just invalid.
Yeah, the court won't proceed with it. They may. The other thing is that, I mean, in the real world, what happens is, you do get you do a motion to dismiss, okay, and then you do get one shot under the rules at amending the complaint, and signing it would probably be, something that you could do. I don't think they're going to throw it out entirely for it, but you would. It is, if they're asking you, for example, if the question said, what are some of the defenses you could raise to this complaint, and there's no signature, then that's something you want to raise in that way as well. So there are also sanctions for violation of some of the above rules. Okay, that's why I said actually Rule 11 is generally what those of us who practiced in federal court would say was, when you hear Rule 11, you automatically think sanctions. And that's sort of what comes to mind. But there are sanctions for violating any of these things that are warranted above by the attorney's signature. If the court determines that there has been a violation, for example, of something was brought for an improper purpose, or that it's not supported by existing law or good faith belief in the facts, then the court can, in fact, impose sanctions on the attorneys, on their law firms, and on the parties. And that could include a number of things. Expenses and attorney's fees of the other side is a common one. But the court can also order, in addition to a penalty, they can also do things like strike pleadings and other things. So that's the initial pleading. I want to talk about a couple of different areas on pleadings just kind of quickly. We talked about the complaint, which is the initial pleading that starts a case. The defendant answers, so that's the second pleading that comes up. Answers either admit, deny, or claim lack of knowledge to answer. There's 2 different kinds of answers, and this is the distinction that you need to be aware of. There's a general denial, which is a simple statement that says, defendant denies each and every allegation in the complaint. Right? That's only permitted in some jurisdictions. It's not permitted in federal court. In federal court, you have to do what's called a specific denial, which means you have to go through paragraph by paragraph and admit or deny each of the allegations. California allows general denials unless the complaint is what's called verified. And verified means there's an affidavit that the party, and not just the lawyer, but the party, the plaintiff or the plaintiff submits an affidavit to the complaint that everything in there is true and correct to the best of their knowledge. And then once the complaint is verified, then the defendant can no longer do the general denial, and they've got it basically turns into a specific denial situation where you've got to go paragraph by paragraph through it. That's weird. Okay. Another area that they do look at is amendment of the pleadings. There's a general right to amend pleadings prior to any other responsive pleading being filed or within a limited number of days thereafter. One of the areas that they tend to test on is attempts to amend after a statute of limitations is run to kind of fix deficiencies in the complaint. When you amend a complaint in federal court to add new claims, if the statute has already run, you can still add new claims to the complaint as long as they relate back to the original complaint. And by relation back, I mean that the claim or defenses arose from the same transaction of occurrence or occurrence. So if you have properly met the statute of limitations, you file the complaint based on one cause of action where you set out all the facts that support it, and then you realize, oops, I should have had a V8. There's another cause of action I can bring. Even though the statute of limitations has run, if it's arising from the same set of kind of operative facts, you can add that additional claim, as long as the first claim was, the complaint was timely filed. Adding parties, you can add a new party only. You can add a new defendant only if it relates back. I should say it only relates back if the defendant had actual knowledge of the suit before the statutory period ran, and he or she knew that they were a defendant that should have been sued. Okay? There's also a concept under California law called Doe Defendants. Okay? If you guys have seen in complaints, you've probably seen it. It's like, A versus B and Doe's 1 through 100. Okay? And the purpose of the Doe Defendants is you're suing fictitious defendants. We call them Does. If you do not know, what you're doing is it's basically a placeholder for a defendant that you want to add later. And if you have added, or if you have Doe Defendants when you file the complaint and then a true name is discovered, you can amend it and change one of the Does to the actual name. The important thing to remember about that is that Doe Defendants are not permitted Doe Defendants are not permitted in federal cases. Okay? So if you see a situation where it's filed in federal court and there's Doe Defendants named and then they want to use the Doe Defendants later, in federal court you can't do that. California it's fine. Federal court it's a non-starter. So
you can amend the pleading that says the prior to responsive pleading. So they're responsible, you can answer.
right.
But then you can, even though they've answered, you can still add a new claim or a new defendant even after the responsive pleading.
Yeah, if it relates back. You can, right. Right. What they're talking about is before there is a responsive pleading, you can add, you can do anything you want before they answer. After, then it's got to relate back. Because remember in a lawsuit, and we also don't often think of it like this, but a plaintiff in a lawsuit could sue in one lawsuit the same defendant for multiple things. I mean, we don't usually see it, but they could be suing for breach of contract and also, some other, collection on a debt or something like that. So, so you could have, one situation or the other that doesn't relate back. But to do it once it's been answered, you do need to, or there's been a responsive pleading, then it's got to relate back. As far as challenging the ways of challenging pleading, which is another issue that may arise, in federal court, again, some of this is just terminology. Federal court is a motion to dismiss, generally a motion to dismiss for failure to state a claim, which basically means that even if everything is in the complaint is taken as true, it still doesn't support a claim for relief as a matter of law. Well, that's what I was going to say. Where I'm getting to is in federal court, it's called a motion to dismiss. In California state court, it's called a demur. Okay, but the nomenclature is different. So federal court motion to dismiss. Demur, again, same thing, asserts that the complaint does not state facts sufficient to constitute a cause of action. But it's important to remember state court, demur, federal court motion to dismiss. So, okay. Okay, areas 7 and 8, I just remember of the 12, areas 7 and 8 that are heavily tested are joinder of claims and joinder of parties. Right? And these are parties and claims that are added or changed following the initial pleadings. And basically the rules of joinder determine which claims and which parties may or must be included by the plaintiff or defendant in their pleadings. The federal rules of civil procedure liberally permit the joinder of parties and claims in order to kind of facilitate prompt resolution and complete resolution. But you need to make sure there's different names for the different kinds of joinder, and you need to be aware of what they are and make sure that you use them. There's really two major issues that you're looking at when you're talking about joinder. And the two questions you have to ask are, does the same transaction or occurrence test apply? And do you need independent subject matter jurisdiction in federal court? I'm going to walk through that, but those are kind of the overarching questions. Remember I said there's different types of joinder and you need to know each of the names. Here they are. There's 4 labels used for that. The first is compulsory joinder, which is a defendant adds or asserts that a third party also is required as a defendant. That's compulsory joinder. Permissive joinder, the plaintiff wants to add another party. Intervention, where a party not named wants to kind of insert themselves into the or intervene into the lawsuit. And then Interpleader, where a defendant wants to add a third party as another defendant. I'm going to walk through each one of these for you. Compulsory joinder basically means that it's a situation where a defendant or a plaintiff asserts that a third party must be joined as a defendant. This requires it to be the same transaction. Party to be joined must have rights or liabilities arising from the same transaction or occurrence as the original claim, and there's common questions of law and fact. So they've got to be involved in it. Right? The second question then you ask on that is the party indispensable or necessary and therefore must be joined. The test to determine whether a party is indispensable or necessary is the court will look at factors. So again, we've got some more factors that you have to look at. You've got to remember this time to decide whether or not a party that you want to join is indispensable or necessary. And you have to look at, can you obtain a full and adequate relief without that party? If you can't obtain complete relief without the joinder of the third party, or there'll be material prejudice to the parties, either both the plaintiff or defendant, without the absent party being involved. And the court will look at the effect of joinder on the plaintiff and on the defendant and kind of the benefits and prejudice to each. They also look at whether there's a risk of dual suits with inconsistent results and whether that's going to be inefficient use of the court's time.
Give an example.
As far as inconsistent result and inefficient use of the court's time,
Yeah, just a dual suit, it's a legal dual suit.
basically what that means is if you've got plaintiff says something is defendant's fault, okay? Under the facts, it's defendant's fault. It's also defendant number two's fault, okay? So rather than, and defendant one it wants to join defendant two because they're saying, look, it's their fault as well, okay? So instead of, it would be inefficient in dual suits if plaintiff sues defendant one in one lawsuit and then turns around and in a totally separate lawsuit sues defendant two on the same on the same facts. That's what that factor means, right? And kind of in line with that, they also look at whether that if you leave defendant two out of it and you don't join defendant two, whether it would, whether their interest would be prejudiced by leaving them out. So, they'll also then consider whether joinder of the party destroys subject matter jurisdiction. In other words, does it change diversity jurisdiction? And can the court exercise personal jurisdiction over the joint party, right? And here's the end result of that. If an indispensable or necessary party can't be joined, then the lawsuit has to be dismissed, okay? Joinder in that case is said to be compulsory. And for that reason, courts often don't like to find that defendants or parties to be joined are indispensable or necessary if they can't be joined. So,
Can you just clarify? This is a little confusing. I was under the impression that if D1 implemented D2 because it's clear that there's some indemnity issue there or that they're joint tort users, and D2 would destroy diversity with B, that under ancillary jurisdiction, the federal court can maintain the action and actually move forward. Is that not the case?
well, that's Interpleader, okay? Right now I'm talking about compulsory jointer. Remember I said there was 4 different things? Okay, let me get to Interpleader and then I'll come back to your question.
Okay.
Okay? Yeah.
I have a question. It's more, I'm thinking maybe in
Okay.
under joinder of additional parties, where the originally talks about it and outline on page 8, it says diversity is required. I assume that means just diversity of citizenship, not diversity of non-citizenship.
But any time that federal subject matter jurisdiction is based on diversity, we call it diversity, but diversity requires diversity and amount in controversy. It's always got to be both, yeah. If one is missing, then there isn't. If you could have diversity of the parties and $50,000, then the federal court doesn't have jurisdiction.
So always leave it as subject matter jurisdiction.
Yes. Right. Yeah.
I thought indispensable party and necessary party were different. So indispensable party is that the party the court was discussing changing, while necessary party is that there are still necessary, but then you can't join them. The court is not going to dismiss the entire suit, but just not having. That's how I understood it. I guess there's some differences, but basically when I read this outline, it didn't seem like
Say what you just said again.
So I thought indispensable party, when the court went, joining an indispensable party to the claim and to the suit, if it destroys, let's say, subject matter jurisdiction, then the court will dismiss the entire case, so they can't take it. Versus necessary parties, they are necessary, however, if you can't join them, the court is just not going to join it, just not join this necessary party, leave them out, but then just adjudicate the case.
Yeah, and you're right on that. I mean, and it says on the, actually, if you look on the bottom of page 35, It says a party is necessary but not indispensable if it would be desirable to enable the court to grant complete relief. And the court can, right above that, the court can proceed with a case without a party that should be joined if you balance the other factors. Okay, can they give, the court can fashion a remedy such that the parties can obtain relief without the necessary party. And in essence, what that's saying is that what you're saying, which is courts are sometimes reluctant to dismiss, so they'll try to fashion it around relief without having a party, without having to dismiss the whole thing.
Oh, I got these under like the, probably like halfway through, it says resolve that if an indispensable or necessary party cannot be joined, the lawsuit must be dismissed. So that's where I got tripped up. If that's the case, regardless of being indispensable or necessary, other than the fact that there's like other things that the court could, remedy, best and remedy, if that doesn't apply, then it has to be dismissed.
Yeah, it tries to give you an exception to that, to having to dump the whole thing.
It's like a clear example between someone, a defendant that's necessary versus indispensable.
Let me think about that one, and maybe we can talk about it on the break. I'll take one more question, and then I know you guys want to understand like every little area, but if we get hung up on this point, we're going to miss some of the big stuff. So, okay. So it's not that they're bad questions. It's just that, again, your point is probably like 3 points. You know what I mean? So if it comes up. So let's move on and talk about permissive joinder. And this is where a plaintiff or defendant wants to add an additional plaintiff or defendant. The same transaction rule is strictly applied in this situation, and the party to be joined must arise from the same transaction of occurrence as the original claim. There has to be common questions or law or fact. In federal court, there is a jurisdiction requirement for permissive joinder. The joinder of the party must be supported by independent federal subject matter jurisdiction. So the claim has to that's being added, must involve a federal question or satisfy the diversity requirement. In other words, you've still got to meet complete diversity, and the claim must be in excess of $75,000. So let me make this one a little bit easier, okay? You file a case, you've got your plaintiff and defendants, and you have complete diversity, right? And you have an amount of controversy, $75,000, okay? If someone wants to join another party later that would have destroyed diversity at the time the case was filed, they're not going to let you add them later. Because essentially what you've done is backdoor them in, right? If it's by permissive joinder. Does that make sense? Okay, so that's why, plus it has to be the same transaction and occurrence, same questions of law or fact, but there is a jurisdiction requirement that they would have had to, in federal court, they would have had to meet the diversity requirement. Because otherwise what you've got is, a plaintiff who tries to add other defendants later, and then they never would have had, they weren't entitled to federal diversity jurisdiction in the first place. Okay? The next way that parties get into a lawsuit is intervention. Okay? And this is where the party not named in the complaint seeks to intervene. You have intervention as a matter of right, where a party can intervene if the parties will not adequately represent the interests of the intervener, and the intervener's rights will be adversely affected by the action. You also have permissive intervention, where the intervener has common claims and rights as the main parties, and the court has discretion to grant the intervention and we'll look to see if the intervener's presence would unduly complicate. Sometimes you have, and the last one, I guess, is Interpleader, where the defendant wants to add a third party as another defendant for indemnity purposes. Okay? The same transaction rule applies. The claim must arise out of the same transaction or occurrence. And where this comes up is the defendant's claim will have a claim against a non-party to the suit, alleging that that party is liable for all or part of the judgment that the plaintiff can recover based on indemnity. This, however, does not require separate jurisdictional basis, and the court can exercise ancillary jurisdiction. So that goes back to Moses' earlier point. Okay, I'm going to give you guys another break now. Come back at 9, and we'll go through some of the last part of joinder of claims and some of the other.
Professor, the question I can ask you.
Yeah. Yeah. Well, if you have yeah, I mean, because you've got, it's not exclusively covered, you've got the state law claims.
So if you have some,
yeah, you can have the
some
Doe
federal plus.
Yes.
Okay, so you have a hybrid, you could go.
Yes.
Okay.
Yeah.
Making sure they weren't messing up.
Yeah.
That's okay. Someone was thinking about
Okay. I've actually never gotten anywhere.
My savior. My savior.
I know.
You think that'll help? Won't hurt.
Yeah, it's all about organization.
But I actually meeting too.
That's why I always tell people on PTs and good news on PTs. You don't have to remember which comes from dividends.
Well, you coming from
Let's start with your thank you. Thank you so much. I really appreciate it. Oh, good. Awesome. But the 12th, wrong. Thank you so much. I really appreciate it. Great. Thank you.
Any more oranges, or that's it?
We used to take a meme out of it.
And then the sim exam is going to be on Sunday time. I said you have to go over the simulated on Sunday. So you get it. And I'll make an announcement because we're doing some structural changes. And you have to do the simulated now. So they're trying to get you grade 1.
It's on the road.
It's okay.
Which way? The two questions or the? I'm trying to do, I didn't have salesman. Yeah, she's doing, do you do sales? Yeah. Are they back?
We're gonna start, right? You want to start?
This mic is on, by the way. Yeah. And I covered it with the, but it's really super simple.
Recording my conversation.
Okay, can I have your attention, please? Because I just want to make a quick announcement, and I will move you anyway. This weekend is Saturday and Sunday. Saturday morning, we have a PT lecture, and we have that homework on various etc. And then in the afternoon, we will return for the lunch break, and we'll do the PT exam and afternoon progressive. That's the bulk of today's Saturday, but I'm going to detail on that. On Sunday, you will come for the criminal control wrap-up NBC lecture, and then you have an hour break, and then you come back for the single exam, which will be tested on common law, criminal, business affairs, and etc. I'll let you, okay. Now, on Saturday, I talked to Professor Lilla if she could start a little bit less, and she needs to come and talk to you at 9:30. So come at 9:30, we will be prompt, we have to start. We're going to go and it's a stipend. She's going to have a short lecture because she has to run to some kind of university event. So I think we will try to start at 9:30. She will end probably close about 11:30-ish. She is going to, and I'm going to draw you a schedule sheet. You're going to put the phone number, the time, which is going to be dates. Normally we put our time for 10 or 11 in the morning for next week. And she'll call you, if you want her number, she'll call you and ask you if you have whatever you need to do, like a 15-minute session consultant. That'll be next week, okay? To make up the fact that she will be able to correct. If you pay her lecture, she won't be able to take it, the kind of questions she will of course return the following week, and if there's anything that she needs to add to the entire report, she might share it with you. And this is coming on the 14th, so Erin will be here and there on Saturday. Erin will be in on Saturday if you want to get any questions like that. You will go for your lunch and come back, do the PT exam, but I will ask you to stay for 12 minutes because I want you to reply super every question that you have done yet. Because I will break right there and then give you your answers. On Sunday, you come at 9:30 to 10 o'clock. Professor Klein will be there at 9:30. She'll go over the interview questions and something so you will know why there's the job and all that. If you miss that, get it to the exams. And at 10 o'clock, we start the pre-up control lecture and a wrap-up. The reason for that, and you stick with that time frame, is because you're going to get an hour lunch and you will return, I think it's at 1 o'clock, to do your next 2 o'clock, you're going to do your simulated exam on Sunday. So, yeah. So what do you want to keep Jeff doing? You started talking to too. You can, you dribble in that's fine with you, but you feel like you're done with you. Okay? And I'll send you an email. She'll probably go over a little bit like she mentioned the last time to everybody how to practice. What did she say? Put back on the clock now. We've got to do the bar clock. No longer the clock we use when it's work for 7 9. Because you've got to get your mind and body ready to do the
thank you. No problem.
So, we were just finishing up with Interpleader and such, and there is, if we go back to our fact pattern, one of the calls of the question actually has to do with Interpleader. If you look down to the third paragraph from the bottom on the question, it says, D next sought to implead IMCO instruments, a state aid firm that supplies thermostats to D. D alleged that IMCO supplied the thermostat in Pat's tub that failed to regulate the water temperature properly. Over IMCO's objections, the motion to implead was granted. The call on that is, was D's motion to implead IMCO, did the court properly rule on it, right? Now, we just looked at that, rule. Interestingly enough, they actually, if you go to the next paragraph, it says then, P then amended his complaint by adding IMCO as a defendant. IMCO moved to dismiss, contending that the court lacked subject matter jurisdiction because of Pat's amendment. The court refused to dismiss the entire action, but dismissed Pat's claim against IMCO. That's also an Interpleader related question. On this particular question, by the way, these two sections were worth 5 points apiece. Okay, so what they were looking for you to address in what I call, question number 3, they wanted you to say, point out that the under the Federal Rules of Civil Procedure, you can implead another party when there's a right of contribution or indemnity from that party. And in this instance, they were looking to add IMCO because if in fact it was IMCO's part that failed, then D would have a right of indemnity against them. Okay, so that's really all you have to say is then that the motion to to implead or Interpleader in this circumstances would be appropriate, and that therefore the court correctly ruled on that. The second part of that question asked you to look at whether whether that destroys jurisdiction or not. And again, when we talked about the rule on Interpleader, remember we said that it does not require a separate jurisdictional basis for Interpleader. So then your answer to that question would be that the federal court can hear related claims under ancillary jurisdiction without an independent basis. Therefore, it would not defeat subject matter jurisdiction. Now, you can fill in a little bit more than that, but that's essentially the answer that they were looking for. So that gives you an example of how Interpleader might come up in a question. So I'm going to talk about joinder of claims now. As opposed to, remember, we just did joinder of parties. Joinder of claims, again, there's 4 different types of joinder of claims. Permissive claims by the plaintiff, compulsory counterclaims, which is the defendant against the plaintiff, permissive counterclaims, also the defendant against the plaintiff, and cross claims, defendant against defendant. That's the nomenclature from federal and under federal law, cross claims. In California, they're called cross complaints, but they're essentially the same thing. Again, you're going to kind of figure these answers, to figure these issues out, we're going to be looking at whether the same transaction or occurrence is required, and also do you need independent subject matter jurisdiction in federal court. So, in federal court, claims, the plaintiff can join, they may have other claims to assert against plaintiff against the defendant, and all of the claims that a plaintiff has against a particular defendant can be added and the same transaction rule does not apply. Okay? Under the Federal Rule of Civil Procedure, plaintiff can join any claims plaintiff has against any properly joined defendants, and the additional claims need not arise out of the same transaction or occurrence. Similarly, there's no independent federal subject jurisdiction required. If a plaintiff's action is properly before a federal court, they can then join any and all claims against the defendant, regardless of whether they're from the same transaction or occurrence or not. And again, if you think about it, that makes sense. You've got a proper plaintiff and proper defendants. They're diverse from each other. They can bring all their claims, so it's not going to defeat subject matter jurisdiction in any event. There is one caveat to that, that if jurisdiction is based, instead of on diversity, if jurisdiction is based on a federal question, then it has to be the same transaction or occurrence. They must have the common nucleus of operative fact that you'd expect the plaintiff to try at the same time. So, next we have what compulsory counterclaims. A counterclaim is a claim by a defendant against the plaintiff. If a defendant has a claim against the plaintiff that arises out of the same transaction of occurrence, the defendant must bring that as a must raise the claim by way of a counterclaim, or else it'll be barred. Okay? So if you have a counterclaim arising out of the same transaction or occurrence, you have to bring it in the same lawsuit. Again, if you think the policy reasons for that, right, the court's going to adjudicate what happened between the plaintiff and the defendant. You know, it doesn't make sense for the defendant to go all the way through and then, after the matter's been adjudicated, then decide they're going to sue the plaintiff, right, on the same transaction or occurrence. So the court requires that any cross claims arising out of the same counterclaim arising out of the same transaction or occurrence must be adjudicated in the same lawsuit, or it's barred. On the other hand, permissive, that's for compulsory counterclaims. Permissive counterclaims, the same transaction rule does not apply. Where the defendant may, but doesn't have to, join all claims they may have against the plaintiff in the form of a counterclaim that arise out of a different set of facts. If it's the same set of facts, they have to bring it. If it's some other matter that they can raise a claim on, they don't have to do it in the same lawsuit. So, for cross claims, so we've got counterclaims, defendant against plaintiff. Cross claims are defendant against other defendant. Right? For cross claims, the same transaction rule applies, and again, the defendants can cross claim against each other as long as they arise from the same transaction or occurrence as the plaintiff's claim in the main action. Okay. The last thing I wanted to mention in terms of claims is interpleader. Okay. Interpleader permits a person in the position of a stakeholder to require two or more claimants to litigate among themselves to determine which of them is entitled to recovery. Most of the time you see that in situations like, for example, you have an insurance company, okay, and you have multiple parties making claims against the policy. They basically interplead and they say, okay, court, you decide who is entitled to this money. We'll put the money up, and you decide who we're supposed to give it to. So that's interpleader. Area 9, I'm not going to go over with you tonight, but one of the other of number 9 of the 12 tested areas is class action suits. There's materials on it. It's pretty straightforward, and for time purposes, I'm not going to go through. I'm not going to go through that one. I do want to skip to area number 10, which is discovery, which is another area that, again, is tested. There's a couple things to know about discovery, and the first one is what's the scope of discovery, okay? The rule on scope of discovery is that under the federal rules, all materials are discoverable unless they're privileged, but they're otherwise considered relevant if they're likely to lead to admissible evidence at trial. So if for the scope of discovery is it's discoverable unless it's privileged and if it's likely to lead to admissible evidence. The CCP, the California CCP, the words are a little different. It says it's admissible or appears reasonably calculated to lead to the dismissal of, to the discovery of admissible evidence. So if you can make an argument that it's likely to lead to the discovery question is likely to lead to admissible evidence, then it falls within the scope of discovery. California has a few limitations on discovery. They can limit the scope of discovery if on the grounds that it could be on the grounds of burden, expense, or intrusiveness, or that that burden, expense, or intrusiveness kind of outweighs any outweighs the likelihood that the information will lead to admissible evidence. In other words, if what the defendant seeks, or the plaintiff seeks through discovery, is going to be really expensive for the responding party to respond to, or is otherwise considered intrusive, and the likelihood that it's going to lead to information that you can use is small, then the court may not, the court could decide to say that's overburdensome and they won't require them to do it. If it's burdensome, but it's going to lead to, there's a high likelihood that it's going to lead to important evidence, then the court will probably weigh in the side of allowing the discovery to go forward. You kind of have to look at the circumstances. I want to talk about work product privilege in terms of discovery, because there is a difference in California, between California and the federal court. The federal rules protect attorney work product. Under the work product privilege, it protects any work or any materials prepared in anticipation of litigation or for trial by the party's attorney. Okay? The difference is, that's the federal rules, okay? So it's anything prepared by the attorney in anticipation of litigation or for trial. Under the CCP, work product protection exists regardless of whether the work product was created in anticipation of litigation. And there doesn't have to be an anticipation of litigation for California. So, in California, the work product documents are absolutely protected, and there's no good cause exception in California under the CCP. You can also never obtain an attorney's handwritten notes or anything along those lines. Conversely, under the federal rules, there is what's called a good cause exception to the work product privilege. If the party under the federal rules seeking the information can show that documents or other material obtained even in anticipation of litigation or for preparation for trial were not or unavailable from any other sources, then in fact they could be discoverable. What do I mean by that? For example, if a witness is no longer available, an attorney has, under work product created a summary of what that witness had said. In California, you're not going to get it under any circumstances. Under the federal rules, you can make the argument that the witness is no longer available. There's no other way to get that information, and therefore the other side is entitled to it. So that's a difference between California and the federal rules. Under California rules as well, the work product protection also applies to attorneys' opinions, and it includes agents and consultants hired by the attorney. Right? One of the tricky things about that, though, is if the expert's or consultant's opinion was produced before the attorney was hired, then it's not protected. But if the attorney hires the expert, then what the expert did is protected. Does that make sense? Yeah, I mean, that's in the real world, it's kind of a game that people play where they make sure that the attorney hires the consultant so that it's that's protected, and there's no question, because then you can say, well, if the attorney's hiring them, it's in anticipation of litigation, and therefore can't be revealed. Okay. Couple of things to just run through, and I'll point them out to you, and then I'm going to turn this over relatively soon to Lisa to have her go over the other question. You should be familiar with the various kinds of discovery mechanisms, interrogatories, which are written questions, depositions, which are live testimony taken under oath, requests for admissions, which are a series of statements that you ask the plaintiff or you ask the other party to admit or deny. There's also requests for production of documents or things, which are normally done without subpoena. You can also subpoena records or compel appearance through a subpoena. There are limits on discovery in California. Okay? In California, you are limited to 35 interrogatories, which if you're actually practicing is not a whole lot. But one of the ways that gets supplemented is California has form interrogatories for personal injury cases and for contract cases, where it goes on for pages and pages and pages and actually gives you in a form a lot of the questions that you would otherwise have to ask in an interrogatory. So you're allowed to have form interrogatories as well as 35 individual interrogatories, for a total of 35 individually written interrogatories. One of the other things that sometimes comes up is discovery sanctions. For failure to cooperate, the federal court can issue contempt orders. It can enter defaults against the non-compliant party, as well as ordering costs to be paid or striking pleadings. California can also issue sanctions for discovery abuse, including money sanctions or imposing what they call an issue sanction, ordering a fact to be decided against the party who's refusing to cooperate in discovery. California can also strike pleadings as well, depending on how egregious the court determines that the other party's failure to cooperate is. So the last thing that I'm going to cover is the last two areas, which are res judicata and collateral estoppel. You guys remember those words? Res judicata is also considered to be, is also called claim preclusion, right? In this rising out of the same cause of action. Res judicata or claim preclusion requires that a party seeking relief in a proceeding has to request all available forms of relief in that action, and they're subsequently barred from relitigating it. So, res judicata, a matter is res judicata if there's a final judgment by a court of competent jurisdiction on the merits, and then it's considered conclusive between the same parties in subsequent litigation involving the same cause of action. Again, this makes sense. If the court decides something between the same parties on the same issue, they're not going to let you relitigate it. Right? So, but again, the requirements are, it has to be a final judgment, which means all the way through the appeal process or the time for appeals is over. It has to be issued by a court of competent jurisdiction on the merits with the same parties or parties in privity with them on the same causes of action. California has an exception to that, okay? California is a minority jurisdiction in the sense that it subscribes to what's called the primary rights theory. And that allows parties to split their causes of action between property rights and personal injury rights. So where this pops up is in a car accident case, for example, and the plaintiff can sue the defendant for property damage to the car in one action and then turn around later and file a separate lawsuit for personal injury, and that wouldn't be barred by res judicata. Now normally it would, and you think it would be, but because California subscribes to this kind of split rights theory, you can split injury and property damage. But that is a minority jurisdiction, and that's in contrast to what you can do in federal court. Federal court requires all causes of action, including personal injury and property, that arise from the same transaction of occurrence to be brought in the same lawsuit. So if you split it in federal court and then you try to bring something later, the court's going to dismiss the second lawsuit. Yeah.
In the primary rights theory, I assume any liability for property damage isn't going to be used for the first amendment.
Yeah, I mean, because they're saying that they're not going to treat it as if it's already been adjudicated. Res judicata does not apply. So
they're just going to start all over.
Yeah, it makes no sense. It's never made any sense to me, but that's the way that it's set up. So, contrast that to collateral estoppel. Collateral estoppel is issue preclusion. Remember, res judicata claims preclusion. Collateral estoppel, issue preclusion, prevents relitigation of certain issues which were already resolved in a previous pleading. A final judgment for a plaintiff or defendant is conclusive in a subsequent action and a different cause of action between them if it was actually litigated and resolved in the first action. So I said it.
You said it much more simple when you said it off.
Okay, let me see if I can do that again. Claim preclusion prevents relitigation of certain issues that were already resolved between the same parties in a prior proceeding. I think that's what I said, right? Yeah. So plain English is usually better, I mean, to be honest. But again, so the factors that you're looking at for that are, it has to be a final judgment. So it was litigated or determined by a final judgment with the same parties, same issues and facts. It had to be actually litigated. And generally there must be mutuality, meaning the same parties. So with that, I think I went through all five, yeah, I did go through all 5 parts of the leisure question based on what we came, yes?
Based upon your experience with Brighton, how important is it that we focus on every new distinction between federal and California?
Well, here's the thing. The bar can test both, okay? And, there are, at least in terms of what I just highlighted, there were really only 3 or 4 areas where there were a couple of differences. If you can commit those to memory, okay? It's kind of interesting, they have not tested that much on California civil procedure. They've mostly been focusing on the federal rules of civil procedure, but they've been able to test on California for like the past 6 or 7 years, and they haven't done it, which leads us to say either one of two things. They're not going to do it again, or gee, it's about time and they probably will. I don't know which way that's going to cut. You mean on the EMDs, or?
Yeah, when you're saying they haven't hit California civil procedure.
They haven't hit California civil procedure that much in the essays, although they can. And depending on who you talk to, they'll say, well, they haven't done it, so they're probably going to do it. And other people will say, I don't know, they don't appear interested in doing it. I don't know what the right answer is, and I wouldn't, you know, to be honest, the only way I would answer that question is say, I don't know, I'd flip a coin. But so with that in mind, I would spend some time on making sure you knew the differences between California and the federal rules. So, yeah.
If it were going to test California, what would be a couple of topics that would be perfect to test California civil procedure? I will always talk.
Well, you know, there's some, for instance, work product privilege difference in California. You know, they could test on the minority rule on the res judicata. There was on primary rights there, yeah. And I think there's another one that's slimming my mind now because I've been. What's that? Closer to the beginning. That's the work product. And I think scope of discovery, actually the scope of discovery is close enough between the two. I mean, I think the definition, the words they use are different, but you know, they're not that. It's more, I think the other, let's see what else there was. Yeah, I mean, and I will also know the difference between you know, what a motion to dismiss and a demur is and that kind of thing. But those are the primary areas. Again, none of it is really that hard. It's just a question of remembering it. So,
I'm not sitting in the stuff here.
are you sure? Well, actually, that's okay because I'm scanning it. It's almost 22, and I know she's got another problem to walk you guys through, which I think is really useful. So, I hope that made it kind of clear. I mean, you know, even when I work with first years with the law school, they all hate the civil procedure. You know, it's like invariably people tell me their hardest classes first years was civil procedure and then either contracts or property. But civil procedure is always one of the two. So, and I think even when you get to the bar exam, civil procedure is nobody's favorite, but hopefully it'll work for you. Okay.
We're going to do Tom's Salesman. It's on page 827. Has everyone read it? If not, yes? I'm seeing a lot of, yay, a lot of nods. I love that. Okay, so I really, I'm kind of excited that I get to do this question with you because one thing I have kind of been asked a couple times is when you have multiple parties or multiple facts, how you treat them. And I like kind of how this got broken down because here you have you kind of have three parties, right? You have Danco, Tom, and Pat, right? So we had to kind of deal with the relationships between those. So I am going to show you how I outlined it. All right. So, of course, because it's I'm following the call of the question, assume the defendants were properly served. Did the California State Court properly assert personal jurisdiction over each defendant? Okay, and don't get tripped up by the fact that they're talking about California State Court. We're still talking about federal civil procedure unless they tell us. So far, that's how they've done it. So I'm going to start with first. Because there's this question. So unless, so I'm just saying we're applying the rules of federal evidence here, or federal civil procedure. I'm so sorry. So don't worry about California for the purposes of this.
Oh, just for the purpose of this?
Yes. Yeah. So far, they haven't tested California extensively, and that's what she means. They're not telling us explicitly right? They didn't say, like, talk about the difference when we do part 2.
So in the grading, if there's people in the road just that are over time.
Yes. Yeah. Yes, exactly. Well put. So for personal jurisdiction, the way I would do it is I would do personal jurisdiction. I would do the rule here. 1, 2, 3, 4 parts of the rule. Then I would do a little bit of analysis based on those. So when I say like the parts of the rule 1, 2, 3, 4, do you guys see what I'm doing? There's a specific way they like personal jurisdiction on the essays.
Where the defendant lives or where he resides.
Yeah, personally served in the state, resident, consent, acts fall within the state. So no, no, and I'm glad you asked that because the way they want it, you do personal jurisdiction, you do traditional methods, and that is 2 things. So again, this is another thing where we're on bar stand. This is how the bar wants it. We're going to do traditional methods, and that is 1, the long arm. Sorry, Laura. And 2 is minimum contacts.
I thought traditional cases were consent and all those 3, and then the later 2 you took to the test for under the law and statute.
That's what we were told.
You were told that, yes.
The 4th column
Yes.
of the PJ is long-arm statute.
Yes.
So,
Yes, and then this. I know. Yes. Yes, what you are saying is correct. And then, yes, you will do it this way.
yeah, but number, see, we have number 4 and 4.
We talked about it before.
I know, yes. This is long arm.
Oh, that's what I said.
Yes, that's why I'm saying yes. We are in bar stand. We are in bar stand where the,
Right, so I
what
got
was the, did you guys ever watch, wait, don't tell me, where the rules are made up and the points don't matter? No? Yeah? You know what I'm talking about? Sometimes you're like, what? This is how they want it. Okay? So, 1, served. 2, resident. I'll write it out more. 3, consent. You know, it might be helpful if we do this. Okay, so you guys have all read it. So the answer starts on page 1204. Let's all open that. Because I know you're all like, wait, what are you just telling me? Why did you say long arm statute? And then again later, you say long arm statute. And then you're going to look at this and you're going to be like, why? Doesn't matter. No, that is how you want to think about it. But when you represent it on the bar, that's how you do it.
Well, it's like an introduction, and then we'll get to
Kind of, yeah, more or less. Yeah. So you see kind of how they did it? They did traditional methods. It's a 2-step analysis. It's the long arm statute and then it's minimum contacts, right? And then we break it down because we have 2 different parties, right? We have Danco and we have Tom. Tom stands for third party, I'm guessing. So we do under minimum contacts, that's where kind of our meat is here, right? That's where we do Pat versus Danco and he versus Tom. So under here is where we do all our analysis. So we have it like this. I-R-I-R-A-C. Yes, Ollie?
The answer to that, is that how somebody actually really
No.
wrote it?
No. Yeah, so sometimes the answers will say student sample answer A, student sample answer B. This is a cut sheet. This is just rule and facts. So this is more like a model answer, like a very skeletal model answer. Yes?
So when you made that, right, so you have all the 4, so 1, 2, 3, 4, like you have the part, like you go into detail, like 1, 2, 3, the traditional basis, and then 4, you go into law and statute, right? So you have all of that made out, like all the rules, and then when you apply it, let's say under Pat v. Danco, right? You you have all 5 prongs for each party separately? Or can I have all 5 prongs and have Pete, Pat versus Danko and like under one section, like the Purposeful Availment, and I'll say there's one rule, and then I'll have under like one incident, and then go Pete, Pat versus Danko, blah, and then Pat versus Tom, blah. Will that organization still be okay?
Yeah, I mean, if you wanted to break it down and put them, do each sub-element and then do Pat versus Danko, that'd be fine. Or you can,
Right.
well, yeah, I mean, you just, the way they've done it here is you put the rule here, and then you do the analysis twice. You've just made it clear to the reader that this is the analysis for Pat versus Danko using those 4, and they didn't break them out into as many sub-issues. Because Civ Pro can be a little bit, sometimes it can be a little racehorsey, so think of it more as we're going to spend our time breaking out our elements in the areas where we need to, and not everywhere. So when you look at the answer, right, at this example here, when they do personal jurisdiction, we're not going to spend forever on each one of these. We really aren't. In fact, we probably won't even do our long arm statute analysis here. We're going to then we'll talk about personal jurisdiction. It's these 4 things. Here, in order for there to defeat the claim, you'd have to meet that, right? That's all the analysis I need. Then I go into traditional methods, and then I talk about long arm. That's when I do my full long arm statute analysis. I know it's strange. Okay? All right. So that's part 1. So part 2 gets a little bit different, right? Part 2 is res judicata. Did you have a question? Sure.
The paragraph right before the follow-up question says California law provides department jurisdiction over non-residents, and it gives you a long arm statute.
Mm-hmm.
And then the answer specifically says, here the fact do not indicate a long arm statute. And then it tells you to enforce the state content of the state on both the Keenan outline and the model and consider that. I just use the long arm statute in the
Well, the one on any basis not inconsistent with the Constitution, that doesn't seem like a different long arm statute. That might be what they're referring to. It's basically the same, right? It's basically where you serve, did you commit the act in that place, or do you reside there? Right? It's basically these. The long arm statute is basically reiterating this, right?
So I guess what I'm confused about is the long run statute, if it doesn't specifically say for a court committed in the state, for a contract in the state, or for business in the state. If the long run statute just says anything in line with the Constitution, isn't it broader than just these acts? Doesn't that mean that there's, I mean, this is very all that.
We'll talk.
I'm looking on a approach book. I did the way you did, so I looked at the
I don't,
statute. So in our approach book, Chair, it does say that if the call in question, right, let's say it's not from California, and then it's applying some other state rule, and it doesn't say what kind of long arm statute it is, then you assume these 3 things and put committed consequence. But then that's why you can apply those, but I think, I don't want to say this, but like, could have been a typo here. I don't know. Because it assumes that there was no long arm statute in the question there actually is a long arm statute.
yeah, no.
I'll show you.
Yeah, we'll look over it together. Yeah.
Because I think I might just be confused on something that LMSR and so I use everything.
No, that's also, it's a very technical point as opposed to like figuring out.
Yeah.
No, it is. It's the because those are the facts of the case, right? Of the fact pattern that we have to work with, right? As opposed to how to structure. So I want to go back into how to structure, and then I'll work with you one-on-one about the case. So for part 2, we just have res judicata and claim preclusion. They gave it to us. What I like about this, so we would talk about res judicata. and then we talk about claim preclusion. And I like the way it was laid out. I actually think it's very clever. Because for both of these, what we're trying to do is look at whether a previous case is similar to a current case. And we have two previous cases, right? We have the federal age discrimination and we have the defamation. So the answer actually breaks them out into the defamation, right? And the age discrimination. And compares those two to the state age discrimination, right? Because they're a different comparison, right? You kind of, age discrimination is probably age discrimination, right? I mean, I don't know enough about it, but, right? But defamation is kind of a different question. So, what I like about this is that we kind of front load the law and then we're able to do our analysis separately and frame it within the facts that we're asked to analyze. So you seeing how they did this answer? I know it's late. I know. I want to get you guys out of here, but I want to make sure that you're seeing where we're going. Jeff, you look confused.
Yeah, I mean, there's just words up there. I'm not interested, like, I'm not hearing like an explanation of like how you're arriving at what you're doing. In a way, like I'm just not. I guess I'm not following, but maybe it's just like
How I'm not you're not following how I'm pulling these two out?
I mean, it's just like race judicata, claim preclusion, defamation. Like I guess I'm just I'm not following yet.
Okay, well, in the facts, right, in the call of the question for 2, it says, is the federal court judgment a bar to any of Pat's claims against the defendant? So what I did was I looked at, right, there's 2 different kinds of bars, right? There's claim preclusion and issue preclusion, or however you want to call them. And then I went into the facts and I looked, okay, well, what are they talking about? What are these cases that are potentially a bar to this current age discrimination case? And so from there, that's kind of how I found those. Is that answering what I'm trying to summarize because I know we've in the past I've spent forever trying to get you to see where I'm getting triggered for the issues. So at this point I'm trying to just show you structurally how I would put this together. Right? Instead of making you read through all the facts and be like, what do you see here? What issues? Right? Is this helpful to do it this fast because it's so late at night? Or do you guys want me to go into it a little bit more? Yeah.
Really into it. So it says, so you have race judicata and collateral estoppel.
Yeah.
And then you put, I mean, test sheet says defamation is state preclusion.
Mm-hmm.
Whenever you have these kind of things, or like issue, and you like, why did you have this? Why does this test sheet make us take the rule? You know, why?
Right. Okay. So for claim preclusion, right, we're looking at whether it's a final judgment of the court, competent jurisdiction on the merits, and the parties are involved in subsequent litigation, and it's the same cause of action, right? So we need to figure out whether this age discrimination claim that we're saying is barred here, whether it's the same cause of action to the 2 previous ones. So I'd kind of pull these out. And then for collateral estoppel, oh, did I do it totally wrong? I did. That's issue preclusion.
Yeah.
Sorry, I hope that wasn't what.
That was like a slash.
Yeah, issue preclusion. It's subsequent action and a different cause of action between them as an issue of a fact essential to the judgment, right? So for these 2 kinds of things, we're trying to see whether the current age discrimination has already been, whether it's already been decided on, or whether it was a material fact in a previous ruling.
I mean, I guess the question is, why did you have to put the rules of recognition while you don't have to use it? So, like, I get why you put it, because
Right, because they're trying to make it easy for us, and they didn't give us the federal age discrimination rule, basically.
Whenever it needs to be a cause of action under these kind of issue, you would just take it over. But if it's.
Well, think of it this way, we don't know if the bar wants us to know what the federal, when we read this, right, we don't know if they want us to know the difference between the California and the federal age discrimination statute, but as long as you say, assuming the facts are the same, it's age discrimination, it's probably very similar, if not identical. Therefore, blank, and I still get the points. As opposed to this, I need to go into this a little bit more, into what actually goes into a defamation claim, right? Because a defamation claim has to do with someone else talking about you. That has nothing to do with age, right? With age discrimination.
Right, but the defamation came after the first lawsuit. It's in the second lawsuit, so like, it doesn't matter.
Yes.
Why do you have to define the rule?
Because I'm looking at whether the previous age discrimination claim bars this defamation claim. Right? Yeah? Because he has 3 causes of action in this current lawsuit, right? He won on summary judgment in the previous one in the federal age discrimination. But for the current defamation one, right, we're trying to see whether the defamation is being barred by that past ruling. Yes. Are you giving me a time signal?
No, I'm trying to draw your attention to, maybe I'm too wrong here, but page 287 says, Flat sued Benson and Tom in the Court of California Court for age discrimination under California law, with contract, uncertainty, and defamation.
Yeah.
Then the question the lawyer says, well, can they bar any of his claims against these people? And so since they do in defamation, with respect to defamation claims, see that this stuff, you do have to state. You have to state the rule. You have to tell the grader whether you know the difference between defamation and what is defamation. And you get the point, correct?
Yeah.
That's what the grader is looking for.
I see some.
Just state the rule.
Yeah. Well, yeah, for the reason of the call of the question, right? Is the federal court judgment, right, the past federal court judgment in the facts of the case, is it a bar to any of Pat's claims? And there's, right?
And in the cut sheet,
Why are you guys struggling
on page
with this?
1205, where the cut sheet says defamation state rules, then you break it down to fact, the actual fact of Tom, and the box is defamation, on the page, and I even say, defendant cannot assert, or whatever so on.
Yeah.
You need to tell the grader that you know that that's the question, you have to obviously, and you answer more. You get that, was it 5-10 points, whatever?
Yeah.
Do you see the trick to answering these questions?
That's what I'm trying to kind of pull out here, instead of to continue to kind of.
Yeah, I see what you're saying, Anna, because there's two parts to the question. So the second part requires you to discuss in more detail information with regard to collateral estoppel.
Yes. And, yeah.
Just collateral estoppel, that's really your only points there, right?
You'd hit it on both. But the analysis would be shorter with res judicata, I agree. No?
Did I tell how to say that?
No, that was, yeah,
I'm responding to that trick.
yeah.
It might sound stupid, but
I know it's a little strange because this is kind of different than how a lot of your other fact patterns have gone. Like this is a world away from evidence, right? Where it's just really short, rule statements, facts, rule statements, analysis, right? This is a little bit more rule, and then we get into these. But it's a good, when you do your analysis section, especially when you have multiple facts or multiple parties, it's a really good way to treat it, right? Because we kind of front load with the rule. It's still an IRAC, it's just a much longer IRAC, right? We front load with the issues in the rule, and then we do the analysis down below. right? So we've kind of talked about the rules up here, and then under the defamation we can say, or we can do it both, there and there, right? Yeah.
They didn't do it
No, they did all the analysis together. There's no, as far as that's concerned, you just, as long as you get it on the paper, right? You don't want to leave the points on the table. You just want to get it on the paper. But either way, if you put it both places or just one, it'll be fine. You guys are awfully quiet. Tired? All right, are we good? Any other questions? I know we have to talk about facts, but any other questions? Okay.